United States, the great state of Florida, and this honorable court.
Be seated. It's amazing, with two advocates of this stature, we got nobody in the courtroom to watch this argument. Coley versus Bromley, Pallets. Ms. McQuasto for the appellant.
I guess I should have. Since we skipped the time clock today, I'm sorry I didn't do anything. I didn't get that right.
You know, it's never done that before.
But, you know, I can make anything not work, as you well know. Good morning. I'm Wendy LaQuasto, Foxy LaQuasto. Ready? I'm here today representing appellant Clyde Coley. I'd like to reserve 5 minutes for rebuttal. This is Mr. Coley's second appearance in this court. The first appeal resulted in an affirmance of an order that was entered in April 2006 that found that Mr. Coley sustained a compensable psychiatric injury as a result of an industrial accident in November 2000, and that compensable injury required psychiatric care and treatment. The current appeal involves an order that was entered in 2009, and it presents this court with a law of the case issue. In the first order, the JCC relied upon Drs. Martinez and Pandya and found that claimant sustained a compensable psychiatric injury. Both doctors described that as major depression, moderate in nature, single episode. The JCC found that claimant was not at maximum medical improvement and that he required psychiatric care and treatment. On remand, the EC authorized Dr. and I'm sorry, I should have asked sooner, but Sabo, thank you. I'm sorry, I'm phonetically challenged in addition to technically challenged. Zabo. The EC on remand authorized Dr. Zabo, and for evaluation and treatment. When he saw claimant, he disagreed that he had major depression. He disagreed that claimant was not at MMI, and he disagreed that claimant required psychiatric care and treatment. So when claimant felt that he was not receiving the treatment that he needed, the psychiatric care and treatment, he requested another psychiatrist.
Well, there are a couple of 800-pound gorillas in this case, which y'all have danced around nicely in your briefs. I appreciate it. This is not a neat application of law of the case, though, and I think both of you probably recognize that. And I guess we all agree that law of the case applies to workers' comp. But I got a couple of questions. First of all, if law of the case is what I understand it to be, why isn't the law of the case simply that as of this date in 2006, your client was entitled to psychiatric care and treatment without any more specificity, number one? And why isn't that simply the ruling here? Because we all know that in workers' comp, causation is an issue that really never goes away under 440.13.
Causation was established in the prior order. Psychiatric care.
Causation was established in terms of compensability of the accident and psychiatric injuries resulting from the accident. But this is not a broken arm, and that's the 800-pound gorilla. This is not a broken arm. This is psychiatric care for which there is no objective testing known to man, I don't think, to diagnose psychiatric difficulties.
They did. He had a 1-week inpatient evaluation, was evaluated by all sorts of staffs.
And continue to dispute whether he performed.
I submit that that's relitigation of what was already decided in the 2006 order. The doctors, after the 1-week evaluation, Dr. Martinez, Dr. Pandya said he has a psychiatric injury. There was some question about whether he was malingering. There was a question of whether he was cognitive.
What if this had been a broken rib? And Ms. Saeed's client had said, we're not going to pay for this broken rib because it wasn't related to the automobile accident. And you went to court and you had doctors disputing, and finally the court said, the JCC said, this broken rib is related to the automobile accident, treated. But instead of treating it, the employer carrier appealed it. And it came back 18 months later and the rib is healed. What are they supposed to do? Because broken ribs heal spontaneously.
Well, I guess there would be a question.
What are they supposed to do in that instance?
I guess there would be a question of whether it had healed properly, and that's why you would be coming back to court, because if it had healed properly, I think probably you would be, unless you were seeking some sort of indemnity benefits for that period, I'm not sure what the medical issue would be at that point. But if it had healed crookedly and was sticking out, then I think
How do we know that your client's depression hasn't healed?
He hasn't received any psychiatric treatment.
Neither had the hypothetical with the broken rib, though.
I don't think that the workers' compensation law requires a claimant to heal themselves, which is exactly what this situation.
Listen, I got your position, and I'm in sympathy with your position. But what I don't understand and what I'm getting at here is what are we supposed to tell them to do? I pretty much agree with your argument down the line. I'll tell you that, except I don't know what to tell the carrier.
Well, I think that the situation is that they have delayed, and this man, and he needs to be. I don't have a problem with if Dr. Szabo had said, yes, I agree, major depression, and you know what, he's recovered from that. But that's not what the situation is here. You know, if what the situation is Szabo said he doesn't have major depression, he's got a personality disorder.
So how are they supposed to know in advance? And I don't want to take up their cause, but how are they supposed to know in advance which doctor I realize this is a minor thing in the case, but they did give you a list of 3 doctors, and your client selected Dr. Szabo. He had some options. How are they supposed to know in advance, any more than you know in advance, which doctor is going to render treatment?
I'm not asking them to mind read or to know in advance. I'm saying that once Dr. Szabo disagreed with everything that was in the order, they had a duty to either seek modification based upon a mistaken fact or a change in circumstances, or they had to authorize a doctor who agreed that he had major depression.
That's what I'm trying to get at.
That's what
the remedy here is for them to authorize another doctor. But what if that doctor doesn't agree that treatment is called?
As I said, I'm willing to concede. If they send claimant to a doctor who agrees that claimant has major depression caused by the injury, and that doctor, he or she evaluates and provides whatever treatment is necessary and comes to the conclusion that, you know what, claimant no longer suffers from depression, and for whatever reason, he is now at MMI.
Ms. Laquasto, they can't know in advance. They can't know in advance that that's going to happen. They can't know in advance that the next doctor is going to say this is a personality disorder.
I'm not saying. I don't understand where you think there needs to be some knowledge in advance as to the doctor that you authorize. I'm saying once you authorize a doctor, and that doctor isn't abiding by the law of the case, the facts that have been established. Let me just suggest, it's beyond the scope of this case, but it would be unethical for a licensed medical doctor to render treatment for a person that he or she did not think required. I totally agree. And if Dr. Szabo doesn't agree, I'm not saying you need to force Dr. Szabo to give
another doctor then. Okay,
another doctor. That's what they asked for, another doctor. Somebody who actually believed the facts that had been established by the case.
That's it. I'm sorry, go ahead.
Well, is that what you asked for? I mean, I thought what you asked for in the petition was treatment, authorization and treatment.
Of a treating psychiatrist.
So is it correct that what you asked for is we want somebody other than Dr. Szabo?
Well, yeah, because he wasn't providing any treatment.
But when will this end?
If he provides another psychiatrist, and that psychiatrist also says he does not think claimant needs psychiatric medication.
I'm sorry.
If the EC provides another psychiatrist, and that psychiatrist also thinks that he does not think the claimant needs psychiatric medications or finds a different diagnosis, what is the EC to do at that point?
File a petition for modification based on a change of circumstances or a mistaken fact and let them litigate it.
What if they say, and I don't know what if they say, hey, we now are resigned to the fact that in 2006 he had a psychiatric injury. We're not contesting that. You don't have to file a petition for modification under the law under 440.13, if you say there's no longer any causation between the industrial accident and the whatever manifestations he's claiming, you don't have to file a petition for modification there, do you?
This is a relitigation of exactly what occurred before. This is a doctor who's saying that he has some other problem that's not causally related
and I agree
to
with
the
you.
accident.
That's what I'm trying to, I agree with you there. I don't know about the other judges, but I agree with that much of the case. But it seems to me, I'm not quite on board with the law of the case. It seems to me like what we're really being asked to do here is enforce our mandate from the per curiam affirmance on the premise that Liberty Mutual has not complied with our mandate.
Exactly.
But
beyond
assigning another doctor, what can we do? Isn't that
Well,
it?
that's what he's asked for, an authorization of a treating psychiatrist to care for the compensable injury that's been established by the facts. You know, if another one comes up, as I've said, I think the only way the conflict in this case that's created by Dr. Szabo's his opinion, the only way that they can then fix that the JCC could fix that conflict is to modify. Is to find that he, or, adjudicate, now he is MMI, because his depression has resolved. But the fact of the matter remains is this man, that the JCC found he has depression caused by the accident. He's not an MMI. He needs psychiatric treatment. He's never been provided that.
See, I'm not sure that helps you, because if that's the case, Dr. Szabo says, and I understand Dr. Szabo takes issue with some of the underpinnings, but what he also says is he's at MMI and he's got a 0% impairment. That's not inconsistent with the first ruling, is it?
Yes. The JCC found that he was not at MMI.
In 2006.
He hasn't, you're creating, in my opinion, that such a ruling would create a situation where delay by an EC for a psychiatric injury would require a claimant to heal themselves and would allow an EC to not provide medically necessary care.
I take your point, but what is the remedy?
The remedy is modification. The remedy is modification.
Let me try it this way. If you sought authorization and treatment of a psychiatrist, they have one authorized. The treatment, this psychiatrist, as best I understand his testimony, said there is no psychiatric treatment that is medically necessary for this claimant at this point. I mean, did I misunderstand? I mean, I understand he also took issue with the causation or the source of the injury, but didn't he say that there's nothing medically necessary from a psychiatric standpoint for this claimant at this point?
He never addressed, yes, but he disagreed that claimant has major depression, which was established in the 2006 order. In your rib example, if you had sent somebody a broken rib and you sent them to somebody to examine their arm, there would be no question that would not be medically necessary care and treatment for the diagnosis and recovery of the claimant. You're going to carve out some sort of exception because this is a psychiatric illness that isn't readily observable. We have a specific diagnosis here. We've got a doctor that disagrees.
But I guess my concern is on the evidentiary record we have before us, all we have is testimony saying there's no treatment that's medically necessary at this point. So what do we do with that evidence?
No medical treatment necessary for the personality disorder that he believes that Szabo believes claimant has. That's not what the issue is. It's medically necessary treatment for major depression. That's what the ruling was in 2006. That's what's not been provided. I see that I'm way into my rebuttal time, so I'm going to yield the floor.
May it please the Court, Tara Saeed on behalf of the appellee. I wanted to address first the law of the case, because our position as the employer carrier on this, reading the plain meaning of the order that Judge Thurman had rendered, the EC shall authorize and pay for psychiatric care and treatment. It doesn't say for major depression. there's a whole discussion of what the diagnosis is. When you look at Dr. Szabo's actual records and what he said, one of the, I believe it was the Axis one.
Well, here too. I mean, this is one of the least neat cases that I can recall.
I agree.
And I'm with you a lot of the way on your argument. Where I'm not with you, though, is how do we simply ignore the fact that we got to know, and I don't see any evidence whatsoever of bad faith on anybody's part here, but how can we ignore the fact that the doctor, insofar as he said no industrial causation, was allowed to overrule the JCC? It's not simply that he said he doesn't need treatment. He said this guy didn't have any major.
Well, actually, though, if you look at his full diagnosis, I think if you look at the Axis 1, which was the adjustment disorder, and opposing counsel provided in her brief, the definition and how that's defined in known treatises. An adjustment disorder is a short-term condition regarding situational depression. So how does that say that he didn't take that situational depression, which one of the previous doctors had seen as a major depression, consider that, but by the time he saw him, that had healed itself? I think something important to look at here, too, is the timeline on this. When you look at when they offered Dr. Abraham, and the claimant attorney said, nope, that's not who we want. They offered another 3. He sees Szabo 1/4 of 08. Not until 10/8 of 08, 9 months later, does the claimant now file a petition. What's happened for those last 9 months? The doctor has remained authorized. He could have gone back in and said, look, Dr. Szabo, I'm still depressed. I've still got all these problems. Who knows if he had availed himself of any of the ongoing treatment, or if he had gone back and Szabo, which is consistent with the cases that have been cited, had said, you know what, I'm not going to treat you. You need to go see somebody else. We'd have a total different situation. We would have a doctor that was refusing to provide continued evaluation and treatment, because as you know, the workers' comp law allows a person to continue to treat as long as they treat once a year. It keeps their statute of limitations alive. So if he had gone back and the doctor said, nope, I'm not going to see you, but he wouldn't avail himself of that. So we rescheduled him an appointment for 1/16 of 09. He misses that. So we rescheduled him again for 2/18/09, and he misses that. Well, does he need the psychiatric care that bad? He's not bothering to go to any of the appointments.
Let me ask this question, and it's completely unrelated to the issue on appeal and probably has been litigated already, but I was just curious about it. I don't think it's in our record, but I'm sure it was in the prior record. He was involved in a motor vehicle accident in 2000. What was so significant about that motor vehicle accident? Did he kill somebody, or why would that trigger such depression? Do we know from the prior record?
There's discussion in there, and in fact, in the very first order, there's a lot of discussion between the competing psychiatrists. But I think, as opposing counsel had argued, that the law of the case out of that was that there was significant psychiatric issues. I don't recall anyone being killed in an auto accident, but it was enough that when the judge heard all the testimony of the physicians, that he felt that this psychiatric condition had arisen out of the events stemming from that. So because of that, that's where that went. But we do feel that, as employer carrier, what are we supposed to do? And using a hypothetical, let's say, I noticed in opposing counsel's brief, there was a lot of discussion about, that the prior doctors that Judge Thurman had relied on were saying that he needed psychotropic medication and counseling. Let's say, hypothetically speaking, we sent the claimant on to somebody else, and this one says, no counseling, we'll give him medications. Well, would we get another petition and say, wait, what about the counseling? Or if the next doctor, I think Judge Kahn, as you had mentioned, had said, well, no, I don't think, I think his depression's over. It was a short-term situational. At what point do we stop?
What happened to the prescriptions here for Lexapro and Wellbutrin? He was on antidepressants at one time.
Correct.
Has that been a long time ago?
Well, from the last time that he was treating, when he first goes to see Dr. Szabo, there's no ongoing psychotropic medications because Dr. Szabo doesn't feel that he needs them. So whether or not he's getting something from his, sometimes physicians that are treating physical injuries will use those type of medications.
There's nothing on the record from the 2009
Correct.
hearing as whether he's getting antidepressant medication.
Correct, Your Honor. And a lot of times, too, those kind of medications can be used as they have alternate. It can be a psychotropic medication, but can also have an effect on pain. So I don't know whether or not, but for sole purposes of treating the psychiatric injury, Dr. Sabo didn't feel that he needed that.
There was a deposition, I think I recall, from Dr. Martinez in the second hearing, essentially conflicting with Dr. Sabo's view, was there not?
Yes,
Was there any obligation of the JCC to appoint an EMA to resolve that conflict, or how was that dealt with?
Normally what you'll do is when you have the conflicting, that the court or any party on their own accord can ask the court for one, and then that decision by the EMA is, or, you know, expert medical advisor, is absent clear and convincing evidence considered to be correct. But I think what we have to do in this case is, as the farthest we can go back, and I pulled the 2 pages of the order on this, the final from the very first order from the 2006 one, when you look at item number 4 from the judges, you know, after weighing all the evidence, the law of the case is the employer carrier shall authorize and pay for psychiatric care and treatment. And then the analysis that Judge Farrell, who later handled the case, which is the subject of this appeal, noted specifically that the claim for authorization of psychiatric care and treatment above and beyond what all has already been provided is denied. I guess the main situation...
Dr. Martinez's testimony, because he updated his examination in December of 2008 and then testified or gave a deposition a couple months later. Why isn't that the only competent, substantial evidence that this court would need to say, I'm sorry, I left one thing out. And Martinez said, hey, things are basically the same as they were in 2005. He still needs exactly the same treatment. Is that right? Am I characterizing?
Correct.
Why isn't that all the CSE that we need to say, do it, and then sort of wash our hands and say, we don't know how you're going to do it, and I understand your dilemma, but why shouldn't we, as the appellate court, simply say, the evidence is there, the injury's the same, take care of it?
Actually, if you look at some of the discussion on that, let me find my notes on that. One moment, please, Your Honor. The doctor had made some discussion about that he felt that it would be reasonable to do the medications. He thinks he'll probably need this. So I can see what you're saying, that his opinion hasn't changed, that he still thinks he needs this. But regardless of that, that is not what the court ordered. And I know that there's nothing to refute that.
Not what court ordered?
Not what the judge of compensation had.
In the first hearing?
In the first hearing.
He simply said psychiatric.
And here's, I think, the difference would have been if the order had stated that the employer carrier shall provide authorization for psychiatric care and treatment for claimants' major depression, we might have a little bit different situation here.
Isn't that implicit in his order? I mean, that was what was litigated. I mean, that's
what he talks about, and they talk about a couple of different issues in there, but when push comes to shove into the end of what we're supposed to do as the medical provider.
Well, counsel, will you agree that Dr. Sabo's determination that the claimant did not have a psychiatric condition related to the accident was in conflict with the 2006 order of the JCC and the mandate by this court?
I won't agree to that, and here's why, Your Honor. Because when you look at the 3 axes and what he found, he did, on the basis of the dependent personality disorder, he didn't feel that was related. The factitious disorder, he felt that was something the claimant was making up. But when you look at an adjustment disorder, there was nothing from my reading of the testimony of Dr. Sabo and the medical record from him saying that the short-term condition, the situational depression, it doesn't say that didn't result from this. He just said that the overall problem, he thought in his opinion, from looking at all 3 different axes, was that the dependent personality disorder was his main problem. But he didn't say, I don't think the major contributing cause of the adjustment disorder was anything to do with, you know, it wasn't related at all to this accident. He just felt that he was at the point that he was done treating.
So the JCC's decision in the current case, the 09 case, is necessarily based upon Dr. Sabo's opinion that there's nothing medically necessary in the form of treatment, isn't it?
It is.
But again, help me understand why, when we have the directly conflicting testimony from Dr. Martinez that he's at the same condition, he still needs treatment. I mean, are we to assume the JCC considered and rejected that testimony?
It's kind of difficult to say because he said that he still feels that he needs that, but Dr. Martinez also did say, it's up to the judge who he's going to believe. There's nothing to contradict that. But as we move forward in the treatment, provide the care. We provide the treatment and care.
I'm not sure it is up to the judge completely, because once Martinez says, hey, he's the same as he was in 2005, I'm not sure that we've got just a really stark question of fact there. One thing I thought about as I reread these briefs is we're not operating in the real world. We're operating in the fuzzy world of both psychiatry and Chapter 440.
Right.
And I would hate to think that whatever we do on this case would flow over to somebody that has an objectively diagnosable physical injury. That's not to say that a psychiatric injury is not real. I don't think anybody in this courtroom would disagree with that. I don't think counsel for the insurance company would disagree with that.
Correct. And, Your Honor, and this is a pre-October 03, so it's a different standard, and so we're looking at something more significant.
I thought there was a finding of clear and convincing here, or is that?
It was, yes. But I think the situation here, when you look at the responsibility of the employer carrier here, and I think you'd already mentioned that there was no bad faith on my client's part for not doing what they were supposed to do. If the client or the claimant had availed himself and gone to any of these appointments, why was there a 9-month gap there? If he was having these psychiatric problems, why didn't he go back? Why wasn't he demanding, let me get back in there and see the doctor?
Maybe because he had psychiatric problems. That again is the 800-pound gorilla. We don't know. My concern in this case ranges from at one end that this guy's got this terrible depression, he's going to end up doing something bad, to the other end that he's going to get unnecessary psychotropic medication, and that's going to ruin his life. I don't know what the answer is.
And I don't either, Your Honor. But I just feel like if he had availed himself of it, the workers' comp law also allows for a one-time change in physician. I didn't see anything.
That's kind of a waiver argument that you're making there.
But I don't see that, but I'm just throwing that out there so the court recognizes, the law does allow that. Let's say he had gone back to see Sabo again and he said, you know what, you're still MMI, there's nothing I can do for you, there's nothing wrong with you. He could have said, fine, I want a one-time change in physician. We would have provided one. But I just don't see that the employer carrier should be penalized in this when they've done everything they should have, and they kept reauthorizing and reauthorizing. And this is very distinct from some of the other cases here where there was a case that the farm stores case versus Fletcher. And in that particular case, there was an order that said to provide medical care as required by 2 specific physicians. We don't have that situation here. Treat this problem. He treats this problem, and as we know from the IFCO communication Mitchell case, which opposing counsel and I are both on that as well, a judge can't make decisions, a judge of compensation claims can't make medical decisions not based on competent substantial evidence, nor can a carrier decide, well, gosh, this psychiatrist didn't do what he was supposed to do. Or like the scenario I put out there, let's say he had seen someone and got counseling, and then he files a petition, well, what about my medications? We can't just decide that. That's a medical decision that has to be made by a physician. So unless there's any other questions, our position on this, Your Honors, is that we've complied with this, and at what point do we stop? Do we just keep authorizing until they find someone who fits the holes?
Just so we're
Yes,
clear,
sir.
and I think we are, when you offered up the first doctor and the claimant didn't like that and chose Dr. Sabo, you're not taking the position that that was their one-time change?
No, Your Honor.
Okay.
We said, here's who you'd like to have. And for cases prior to October of 03, we were required under the law that you would provide a list of 3. But normally if someone asked for authorization of physician, we would set one up. And then if they said, well, no, give me a list of 3, we give them a list of 3. And they're usually ones that were within network, that the insurance company has contracts with. And that's when they picked Dr. Sabo. So I just don't feel that my client has not complied with this. We have, but at what point do we stop and say, do you keep going till you get someone who gives you everything you want? I would hope that the court would find no, that we had complied. And I thank you for your time.
Thank you.
In answer to your questions about how he got the psychiatric injury, part of what went on in the prior proceedings.
I don't want you to waste too much time
No,
on
no,
it.
no, I know,
just
but
a basic
I do want
question.
to answer this. What was significant is there was a whole battle about whether he had some sort of organic cognitive brain damage as a result of the accident and whether that was causing a psychiatric injury. And in fact, Dr. Martinez did diagnose was cognitive disorder in addition to major depression. So there's a theory that there's something wrong with his brain, and that's why this is a really complicated psychiatric case. It's just not your run-of-the-mill major depression case because of pain. This is a question of a 1-week inpatient evaluation to determine this. So
It's the one question I had, and if it was completely off base, let me know, about the EMA. I mean, again, I saw two conflicting medical opinions here. Was the JCC obligated to bring in an EMA?
I think that, I pondered that question myself. I think that this is a law of the case situation and that modification was the only way that this could have been changed. I think on an EMA might be able to come in on a modification position, and that is actually the solution for the EC. They said, how many people do we need to authorize? Well, you need to authorize somebody.
I'm going to be honest with you again. I do not understand, and I'd like to see a case that says how law of the case can control future medical care under Chapter 440. I just don't get that at all. You might need it today and not need it tomorrow. That doesn't mean you didn't have industrial causation. This is a general question.
I just keep going back to the point that if you're not going to enforce the rulings that have been made in orders about what's treated, then you're going to create a situation where ECs are going to continue to delay and delay and delay in providing treatment to the...
Going back to my question, though, again, the EC provided 3 doctors. Claimant selected Dr. Sabo. And, of course, claimant's concerns with Dr. Sabo's recommendations and opinion. So if the EC had given the claimant a list of 3 additional doctors, claimant selected the doctor the second time around. And the second doctor has the same opinion as Dr. Sabo. What is the EC to do?
Move for modification. Mistake of fact. This man does not have major depression. This guy has a personality disorder. But this is relitigation.
That's exactly my question, and I just don't agree with that. Why do you have to move for modification as to need for future medical care? I'm not so sure that's what the law is. We've got cases that say that even when we've got a bunch of cases now that say even when you have waived the right to contest compensability, you can always contest medical causation. So here they got no right to contest compensability.
Causation was established in the 2006...
As of that time. And I take your point. I don't appreciate you putting it on us and say, if you do this, but I understand where you're coming from as an advocate. I take your point that we as a court should not countenance a carrier just sitting on their hands while the claimant suffers for 2 or 3 years. I think we all agree with that. But I get back to my original question, which you didn't answer, which is implicit in almost all of these questions. How does law of the case apply to future medical care?
Law of the case says that when facts and issues have been established as between the parties, those facts and issues are controlling and all subsequent litigation in the lower and appellate courts.
In this case, what are those facts and issues?
The facts and issues is that this man suffers from compensable...
Suffered from.
There's no evidence to show that he has been miraculously healed from major depression. All that you have is somebody who...
Other than Dr. Sabo's testimony that he doesn't have it.
He doesn't, since he doesn't diagnose it, he doesn't say that he's been healed from it. He just disagrees. And he's disagreeing with the order, and by accepting him, the JCC, a different JCC, I remind you, entered an order that conflicted with a prior order on established facts and issues.
So just to be clear, your view of Dr. Sabo's testimony is that he said not just that he doesn't have the problem now, he never had the problem. I mean, isn't that the only way we could get to him being inconsistent with the prior ruling?
I don't think I think that he disagrees. I mean, I think Dr. Sabo said in his deposition, well, he wasn't deposed. See, that's part of the problem here is there's no explanation there. But, I think because of what his diagnosis is, you have a disagreement. And how do you remedy that disagreement? That's what the issue is how do you remedy a disagreement with a doctor authorized on remand? And he renders a conflicting opinion.
Let's go back to Judge Lewis's question on your first question on your rebuttal, which I'm going to have to tell me again, what is exactly the relief that you want us to award you if we agree with any of the arguments you've advanced?
Reverse the order and remand with directions.
Yes, now start. I want to write it down.
Well, be quoted on
not remand with directions to comply with some order. I want to know exactly what you want. Exactly what you want.
To authorize a psychiatrist to evaluate and treat claimant's compensable major depression.
How could they not come back on a motion for rehearing and say, that's what we did?
Dr. Szabo did not diagnose, did not treat major depression. That's an established fact from the 2006 order. As Judge Weatherall said, it's implicit because this judge relied upon...
How do they comply? If they were to throw up their hands right now and say, okay, we give up, we'll do it, how would they then comply with this? What would they do over in Jacksonville or wherever Liberty Mutual is? What would they do to comply with this order of this court to authorize a psychiatrist to evaluate and treat?
They would authorize the psychiatrist. Claimant would go to that psychiatrist and be evaluated. That doctor would render an opinion. If that opinion said he doesn't have major depression, never had major depression, then you need to file a petition for modification to cure the conflict that now exists based upon a change in circumstances, and that would answer your causation problem for future medical change of circumstances, or a mistake in fact in that Dr. Pandy and Martinez were mistaken in diagnosing him with major depression from the get-go. And that's how this whole thing gets resolved. This doesn't cause any departure from the established law, the case law. It just requires y'all to do...
If that doctor says that claimant has no major depression at this time in history of MMI, what is the carrier to do?
Then that would be a modification that it's healed, that it's maybe an EMA needs to be appointed at that point to resolve the situation. You know, maybe that's where your EMA comes in, is on a modification or something like that. But I think that, you know, that there are ways for this situation to have been corrected. And, you know, you talk about the EC throwing up their hands like, what are we supposed to do? That's exactly what they did. They authorized one person who disagreed, and then they've thrown up their hands. We don't know what to do.
Indulge me just for a moment. Do we have any record evidence as to what happened for this 9-month period that the EC referred to in her argument where he didn't go back to Dr. Szabo?
I don't know. I just know that that's when the petition was filed, that he went to see, and I will say, he went to see Doctor in January. She said the petition for benefits was filed in October. I don't know why there's a delay. I do know that he did miss the rescheduled appointment in January. I didn't see anything in the record that indicated that he missed the February 09, but as Judge Kahn pointed out, it is a psychiatric problem, and oftentimes people don't like to admit those or seek treatment.
Thank you.
I'm way over my time. Thank you very much for your time. We ask you to reverse and remand.